All right, Crim 1, we have Chapter 7, Legal and Special Issues in Policing. I think this is actually kind of an interesting chapter, so hopefully you will as well. But we start with the Fourth Amendment. The Fourth Amendment of the Constitution does protect all of us against unreasonable searches and seizures. So it's important to define what a search is, what a seizure is, and what is reasonable. So a search is pretty easy, and I think most of you, if I would say, what does it look like when a person or object or location is searched by a police officer? Most of you are going to say that the officer is looking for something or feeling for something, or so that would be a safe assessment of what a search is. What is a seizure? This one gets a little bit more complicated, and obviously we're not talking about a medical seizure. We're talking about a police officer taking something from someone or somewhere. So again, that seems fairly common sense probably, but you also have to consider that seizing someone's freedom is something else that can be seized by a police officer. Okay, so that's the one little curveball I wanted to throw in there. And then, what is reasonable? This is like the question of the hour every hour. What is reasonable? Whose opinion of or definition of reasonableness really matters? I mean, ultimately, when we come down to it, it's going to be a judge that gets to decide what is reasonable. But for purposes of this discussion, I would say, what would a reasonable person believe is reasonable? Again, am I reasonable? Are you reasonable? I don't know. These are really vague descriptions, and that's just the way our law is written. There are some areas where it's pretty vague. Reasonableness, of course, we just kind of talked about that. These are different types of searches and seizures. You can have a search with a warrant. That warrant has to be based on probable cause permitting the police to conduct a search. A warrant is a document that's signed by a judge and typically lays out pretty extensively and thoroughly exactly what the officers want to search and usually what they're looking for. So what is probable cause? That is the amount of evidence necessary to obtain a warrant or conduct most searches or seizures. Probable cause, generally speaking, that a crime has been committed or is about to be committed, and that the person that you are searching is the person who committed that crime or is about to commit that crime. All right, so probable cause. Stop and frisk. This is a technique that some officers use, and it started from this case, Terry v. Ohio. And in that case, the officer was, I love it when I'm in the middle of saying something and my brain just turns off. Okay. His name was Officer McFadden, and he was kind of staking out this area in Ohio, of course, where there'd been a string of robberies lately, and he was undercover and staking out the area and looking, watching, paying attention, and he saw these guys. There were, I believe, 3 of them were walking back and forth in front of this kind of like pawn shop, jewelry store-ish place, and they kept walking back and forth. And they kept looking in the jewelry store. It looked super suspicious to him. So based on the fact that there was reason for him to be there because there had been numerous robberies in that area in the past, and that he believed, based on his 25 years of experience as a police officer, that the behavior of pacing back and forth and looking in the window at the store was suspicious, he believed that would give him the right to at least stop and talk to those individuals with reasonable suspicion. So when he stopped them, in order to make sure that none of them had a gun and was going to shoot him or stab him or any of that kind of stuff, not that they would stab him with a gun, but you know what I mean, he did a quick pat down the suspects for officer safety. And while searching them or doing the quick pat down for officer safety, one of them was in possession of a gun. And so that's how the whole case started. The court agreed that it was reasonable for Officer McFadden to be suspicious, to have reasonable suspicion, and to pat those gentlemen down for officer safety purposes only. So only for weapons, not drugs, not anything else, just weapons. So reasonable suspicion, less than probable cause, but more than a hunch. Again, super vague, I know. That's kind of the way the law is. Search incident to a lawful arrest is another type of a search. This is when a person is being arrested by a police officer. Anything in their immediate area, basically anything that they have access to, they can reach, touch, the officer can search. Now, can they search inside someone's trunk, locked trunk of their car after they arrest them? No, because the person who was being arrested couldn't reasonably reach his trunk at the time of the arrest. So hopefully that makes sense. So when officers do what I call bad searches or illegal searches, any evidence that they obtain during those searches cannot be used in court against the defendant. There are a couple of exceptions to that, being the good faith exception, meaning that the officer believed wholeheartedly that he was not doing an illegal search, and inevitable discovery, meaning that at some point in time it is inevitable that that evidence would have been found anyway. Again, I know these are kind of vague. The Fifth Amendment. You've all heard this before. I plead the Fifth. Fifth Amendment states no one shall be compelled in any criminal case to be a witness against him or herself. This amendment gives us the right to plead the Fifth. This is also where Miranda came from, a Miranda warning, so that we all know that we don't have to talk to the police officers and we don't have to talk to testify against ourselves in court. And Miranda versus Arizona. You have the right to remain silent. Anything you say can be used against you in court. You have the right to consult a lawyer and have a lawyer present during questioning. If indigent, meaning broke, you may have a lawyer provided at no cost, and you have the right to end questioning and consult a lawyer at any time. So, let me see here. When does this have to happen? This needs to take place when a person is in custody or they feel they're not free to leave and they're being questioned. All right, so we see a lot of people on the TV shows that the second they throw the handcuffs on them before anyone's even thinking about talking to them, they're read their Miranda rights. And it's also really important that the police officer have evidence of a waiver of their Miranda rights, have evidence that the defendant understood their rights and wants to talk to the police. So Miranda was a case from, obviously Arizona, where a defendant had raped a woman and he got arrested, and he told the police the whole story because he claimed that he did not know that he didn't have to talk to them. So hence Miranda versus Arizona. When is it required? Again, a Miranda warning is required when a person is in custody or they feel they're in custody and they are being questioned. So we had a kid when I was working over at Hoover. We had him in the back of the patrol car. We were getting ready to take him to juvenile hall. He was clearly in custody. He was in handcuffs in the back of a police car. I turned around and looked at the kid because it was really hot outside that day. And I said, "Can you feel the air conditioning?" And the kid said, "Yeah." I said, "Good." Then he continued to say, "The bitch deserved it." Okay, so no one Mirandized him before he made that statement. Because nobody was questioning him, Miranda is not required at that point. It was not required. I asked him if he could feel the air conditioning. I didn't ask him if he hit the girl or what happened. So, in custody and interrogated. and this does apply to testimonial evidence only, meaning testimony, meaning words. And there is a public safety exception. If somebody's thrown a gun on an elementary school playground and they get contacted by the police can ask them, where's the gun, for public safety issues. So that is Miranda. The Sixth Amendment, all criminal prosecutions shall enjoy the right to have assistance of counsel in his defense. So we all have the right to have an attorney. When does this right attach? Technically, it attaches when the discussion becomes accusatory or when the defendant becomes a suspect. I would argue that basically any time during a scenario, a defendant should be able to have an attorney. Think making a 911 call. What if, someone broke into my house and I shot them? And I called 911 and I said, I just shot somebody. Is that statement going to be used against me? It is, right? Because I just basically said that I shot someone. So this is a tough one as well about when does the right actually attach. But it's when proceedings become accusatory. Use of force. When can officers use force? How much force can they use? And what other jobs allow the use of force? Officers can use force when they are trying to keep someone from escaping, and in order to protect themselves. How much force can they use? They can use the amount of force necessary to stop the threat or contain the situation. So if somebody is, yelling at a police officer from across the street, and the officer tells them, come here, and the defendant refuses to come over there, can the officer pull out his gun and shoot him? Of course not, because there was no need to use deadly force for such a low-level offense. But also think about it. We're going to talk a little bit more about this in one of the other slides, but think about what other jobs there are where people are legally allowed to use force. And most of you are not going to think of very many of them, I don't think. That's generally not very many jobs are like that. Medical workers probably. But anyways, next, the continuum of force. So, the use of force can vary from officer presence at the lowest level to deadly force at the highest level. It is a training aid for officers so that they know how much force is allowed in certain scenarios. Does the officer have to go through level 1, level 2, level 3, level 4, and then on to level 5 in every scenario? If level 5 is warranted, no. So it is the amount of force that is required to stop the threat. Okay. Pursuits. Police officers will sometimes find somebody and try and pull them over, and the person will take off. Should they pursue the suspects? There are arguments both ways. If they don't, that suspect's going to get away. And it depends a lot on what the suspect is accused of doing. But unfortunately, sometimes these pursuits end in horrific accidents where innocent people die. So it's a tough one. A lot of agencies will call off pursuits because of the risk of death or great bodily injury to others in the community. So police officers, there's lots of different types of enforcement, drug enforcement, gang enforcement, and intimate partner violence, which we're seeing a lot of. So these are just different types of maybe assignments a police officer could have. Stress. Stress is huge in the police world. Why do they experience stress? I cannot tell you how stressful a day is, just any given day for a police officer. They can go from having the most boring moment of their life to being shot at in the next, 10 seconds. So a lot of stress. How can they cope with it? Exercise, family time, therapy, alcohol, and drugs. I know. Suicide and divorce are very significant issues for people in law enforcement, more so than the general population. It is a tough job, and it's a career that you need to really be prepared for mentally before you go into it. And that's it.